My name is Jim Sellers. I'm a plaintiff's trial attorney who practices in Oregon, Washington, and I'm going to try and answer some questions for you that I have clients ask me bills for all of your treatment in order to properly present the claim and to make sure that there's payment made for the cost of the care. So the first thing it has to do is we have to collect all those. There's a couple of different ways to do that. One is the attorney's office can write each one of the healthcare providers and request the records and bills from those providers. There is a bit of a problem with that. One is healthcare providers like hospitals and doctors tend to put requests for records from attorneys on the bottom of their pile on their desk, and they don't get to it very quickly. It's not a high priority. The second problem is they attempt to charge large amounts of money to obtain those records. So, for instance, a typical charge that a healthcare provider will attempt to impose is a $25 administrative fee and then approximately $1 per page of every medical record that you request. Sometimes I'll request medical records only to find out that the clinic or the hospital that I'm requesting the record for does not have any records because there's been a mistake about whether you treated there or not. And if that happens, they will send back a response in which they will impose a $25 administrative fee and charge $1 for the one-page letter that I sent them requesting the record. And so that's kind of the thing you run into. Frequently what I'll do, particularly with providers that are notoriously bad about providing records, is I'll ask my client to go down into the clinic and request the record. Now, there are a couple of rules of thumb when the client does that. One is, if the client is asked why they need the records, the last thing the client wants to do is to tell the clinic that the client wants the records to give the records to an attorney. Because what the clinic very often will say is, well, we have to have the request from the attorney. Or they will say, that's okay, we'll mail it directly to the attorney. In which case, they send the records along with an exorbitant bill. The problem with the bill in particular is it's a bill that ultimately the client ends up having to pay. And so the client can avoid a lot of that cost by requesting the records themselves. And then send them in to me. And what the client tells the clinic or the hospital, if they're asked why the client wants the record, the client says, well, I want the records from my own personal records. I want to have a record of my treatment. And usually that's sufficient. Now, occasionally the client will also get charged, but more often than not, the client doesn't get charged. Therefore, we obtain all the medical records. Frequently, even though we have the records, we need to solicit a letter opinion from one of the doctors regarding the patient's conditions. And this will require us to go meet with the doctor. Having met with the doctor, we'll send the doctor a confirming letter outlining what the doctor told us about the patient's condition and soliciting a response to that letter in which the doctor confirms, yes, that is exactly what the doctor said, which becomes proof in the submission of the claim. So frequently we'll need that. In addition, we'll need photos of, in the instance of auto accidents, of the damage to the vehicles is available, accident reports by the police, copies of repair estimates. If there's people that have tended to the injured person, in other words, came over and prepared their meals or did their laundry or mowed their lawn, at least in the state of Washington, we're able to recover for the fair value of those services, and those become a part of the